Okay, we are set. Welcome everyone to the court's September administrative public hearing. Thank you for being here. We have a large number of speakers, which we are always grateful for. So let's dive in. The first item is ADM file number 2019-40, which is the proposed adoption of Administrative Order 2025-X, proposed rescission of Administrative Order 2012-7, and proposed amendment of MCR 2.407 that would clarify when, from where, and how a judicial officer may participate remotely, subject to their chief judge's approval. And we have one speaker for that, and that would be Judge Kevin Cox from the Third Circuit Court. Judge Cox, are you here? If so, I'm looking, I see the screen, but go ahead and proceed. You turn your camera and your microphone on. Maybe not. Okay, we can come back to that one. That was the only speaker for that. Let's go on to item number 2, which is ADM file 2022-34, proposed amendment of MCR 3.991 that would clarify the process for judicial reviews of referee recommendations in juvenile cases. And we have one speaker for that item, and that is Josh Pease from the State Appellate Defender Office. Mr. Pease.
Yes, thank you, Your Honor. Good afternoon, Josh Pease of SATO. While we did not submit a written comment on this ADM, we did send the proposal a couple of years ago, which became this ADM. We originally suggested amendments to MCR 3.991 because, as currently written, the rule limits meaningful review of a referee's recommendations by allowing a judge to enter an order at any time during the period for requesting review, and the entry of that order cuts off the ability to request review. If a judge signs a recommendation into an order an hour after the referee issues them, there is effectively zero opportunity to request review. We've carefully read all the comments and spoken with some interested persons about the ADM and proposed amendments to 3.991. And we recognize that the proposal we had originally sent to this court caused concern for trial courts. As such, we recommend that the court amend 3.991 as suggested by the State Bar Board of Commissioners and Children's Law Section. As stated in some of the comments, there are good reasons for allowing judges to quickly sign orders, particularly for an order removing a child from an abusive household. Part of the issue with this structure, though, is the restrictive nature of a motion for rehearing under MCR 3.992, which does not allow a party to argue that a judge or referee wrongly decided an issue which was presented. When a judge very quickly signs an order removing a child and the party wants to argue that the referee wrongly recommended that the child be removed, the only remedy would now be an appeal, which takes significantly longer. The proposal from the Board of Commissioners and the Children's Law Section balances the need for judges to be able to quickly enter orders in these circumstances to protect children, while still giving attorneys and parties the ability to obtain meaningful review of a referee's recommendations in the trial court in an expedient manner, rather than being forced to endure the delays of a traditional appeal. And the expanded time for requesting review from 7 days to 14 would give more flexibility to attorneys and parties to request review when their caseload or other obligations may limit their ability to sufficiently explain the need for review. This proposal would also allow for more meaningful judicial review of referee recommendations, which better insulates the rule from any concerns that a judge may be rubber stamping a referee's recommendations, which may run afoul of MCL 712A.10 as interpreted by In Re AMB. Judges must maintain the final decision-making in juvenile court proceedings, and expanding the ability of parties to request review of referee recommendations helps ensure that it is the judge, not the referee, who is truly making the decisions in a case. In summation, we stand behind our original suggestion to the court that MCR 3.991 be amended, but are now convinced that the comments from the state bar groups better protect a court's ability to act quickly for the safety of children, while simultaneously giving parties more access to full judicial review of referee recommendations. Thank you.
Thank you, Mr. Pease. I'm wondering, I have a question, wanting to get your opinion on, would a possible solution could it also entail amending 3.992 to change the standard for reviewing that decision?
Yes, I think that amending 3991 and 3992 together certainly goes a long way. At least one of the comments I believe had said, hey, let's just fix 3.992. Part of why I believe that doesn't fix the issue is that these motions for rehearing generally go back to the same jurist who heard the case in the first place, meaning if I want to have a rehearing of the referee recommendations, it generally goes back to the referee rather than having the judge do the review. So I think amending 3.991 for that greater flexibility while simultaneously amending 3.992 to make it easier to obtain a motion for rehearing is, at least in my mind, the best solution.
Okay, thank you very much. Any other questions for Mr. Pease? No? Okay, thank you, Mr. Pease. And I see that Judge Cox is here. I'll jump back up to item number 1, having to do with amending the AO and the court rule regarding when and from where and how a judicial officer may participate remotely. Judge Cox, thank you for joining us.
Good afternoon. First of all, although I'm from the Third Circuit Court, the Wayne County Circuit Court, I'm just one of 50 plus trial court judges. And if you were to ask the 50 plus trial judges what their opinion is on the rule we're talking about, you may get 50 different opinions. I think everybody has experienced the benefits of judicial proceedings being conducted remotely. There's no doubt that remote judicial proceedings are beneficial, and it has made access to our courts much easier for many people, and that's certainly a goal of our system. The real issue, and I don't have an answer for you, by the way, I just have a problem that hopefully you will think about. The real issue is how do judicial proceedings, how are they, remote judicial proceedings, how are they viewed by the public? And does the public have the same trust in, judicial proceedings when they're remote as opposed to in person? And I think if there's probably consensus that very often there's a lot of virtue to remote proceedings. The problem is, are we going to have a system of trial courts where judicial proceedings happen remotely and where judges don't appear in their courtrooms for perhaps weeks, perhaps months at a time? Mm-hmm. And if that's the situation, how does the public feel about that? That is a challenge in our court because there is a lot of differing opinions. My own personal opinion is if judges don't come to court for weeks at a time, it lessens the respect to the court system. But again, like I started my remarks, people have different opinions on this issue. Justice Hood, I know, was a trial court judge in the criminal court, and I think by necessity, criminal court judges have to be in their courtroom. I know it's been a while since Justice Zara was a trial court judge, and they weren't doing remote proceedings back then. But if you were to look at our statistics in Wayne County, and if you were to look at judges' cases over time standards, for example, and I look at things like this, you will see that the family division The judges have remarkably efficient dockets. Very few of them have cases over time standards. In the civil division, the judges have very respectable, in my judgment, numbers when it comes to cases over time standards. So it is clear that in both of those divisions that comprise probably close to 40 judges, dockets are being handled efficiently. But again, not to repeat myself, the issue becomes public trust and public confidence in judges and the decisions judges make when arguably people haven't set foot in a courtroom, in a court building for weeks at a time.
Thank you, Judge Cox. We appreciate you being here and giving us your comment. Any question for Judge Cox?
I do. I listened to every word you said, and I don't know, are you in favor of this rule or against it?
I want to be like Switzerland. I don't want to, it is a very complicated, I don't want to offend a lot of my colleagues that for the most part work remotely because they're efficient and they're smart and justice is served. But I really struggle with the perception and the perception that judges are, not much different than the consumer complaint department at Amazon, where judges have headsets, they're talking to people essentially over the telephone, and they're making decisions, not in a courtroom, but for all intents and purposes, over the telephone. And there's something troubling about that. And I think there's virtue in being in court, being in a building that commands a certain respect and tradition in in-person proceedings. And should that be the judgment of the chief judge? And I have great respect and admiration for our chief judge. But I also have great respect and admiration for an awful lot of judges that are my colleagues, that for all intents and purposes only come to court when they have a jury trial. It's a troubling issue, and I'm glad I don't have to be the decision maker.
Thank you.
Thank you, Judge Cox. Anyone else? Okay, thank you. We're going to move on to item number 3, which is ADM file 2023-12, proposed amendment of MCR 3.602 that would clarify the applicability of MCR 3.602 and the Michigan Uniform Arbitration Act. And we have one speaker for that. That is Larry Saylor, State Bar of Michigan's Alternative Dispute Resolution Section. Mr. Saylor.
Thank you, Your Honor. I'll be very brief. This amendment is intended to resolve some inconsistencies between the court rule and the Michigan Uniform Arbitration Act, which was adopted in July 1st, effective July 1st of 2013, and provides that petitions to vacate, modify, or correct an arbitration award need to be filed within 90 days. That of course applies to arbitrations that are not governed by the Domestic Relations Arbitration Act, so this has no impact on those arbitrations. But the court rule has different deadlines, as short as 21 days if there's a pending proceeding in court, or if the grounds for the arbitration or for the motion is fraud or abuse of the system. This would correct this amendment, which is proposed by the ADR section, would correct that and provide that the court rule is overridden by the statute except where there is another statute that would apply. So we think this is a valuable amendment, although a technical one. Thank you.
Okay. Thank you very much. Any questions? No. Okay. Thank you, Mr. Saylor.
Thank you.
Okay, moving on to item number 4, ADM file 2023-22, regarding a proposed amendment of the Michigan Rules of Professional Conduct 6.1 that would clarify and expand the scope of pro bono service. And the first speaker we have on that is Jennifer Bentley from the Michigan State Bar Foundation.
Thank you, Chief Justice Kavanaugh. I'm Jennifer Bentley, the Executive Director of the Michigan State Bar Foundation, and there are a few other people here to speak about this today. So I want to thank you for taking this important issue into consideration. The proposed rules submitted by the State Bar of Michigan and supported by the Michigan State Bar Foundation, the Legal Services Association of Michigan, and the state planning body would provide clarity to Michigan attorneys about professional obligations and encourage more attorneys to do pro bono and pro bono legal services and provide financial contributions to those in need. The Bar Foundation Board President, Craig Lubin, submitted a letter on behalf of the Michigan State Bar Foundation Board. The Bar Foundation also vetted the suggestions and the proposal that the State Bar of Michigan submitted with the steering committee that leads the Access to Justice campaign, and that is comprised of members of the legal community, including large law firms, small firms, and corporate counsel. I think most of you know, but the Access to Justice campaign was centralized in 2018 and raises money for 14 civil legal aid organizations throughout Michigan. The campaign is a partnership with the state bar and administered by the foundation, and 100% of the donations are distributed to legal aid programs. Many members of the bar from various size law firms and state bar leadership were involved in the transition to a centralized model and put trust in the foundation to lead that effort. I'm going to address two really important differences in the court's proposed rule and the proposal submitted by the state bar and supported by MSBF and other stakeholders. First, the current voluntary standard and rule proposed by the court supports the idea that if someone volunteers, they discharge their obligation to donate. The ABA model rule adopted in 1993 and the majority of states' rules say lawyers should aspire to provide pro bono services and contribute financially to support organizations that provide services to persons of limited means. Not all states have rules, but the ones that do, 30 states use and rather than or in their Rule 6.1. Second, the state bar's proposed amendment suggests donations to the ATJ campaign and charges the foundation with the responsibility of regularly determining and publishing suggested annual donation amounts. The voluntary standard recommending 300 was adopted in 1990, so long time ago, and amended in 2012. Having the foundation as a trusted entity determine amounts would allow for flexibility and consideration of national data, changing economic conditions, and feedback from community stakeholders, legal aid organizations, and other volunteers. The court has an opportunity to adopt a rule that will further access to justice throughout Michigan, and I really encourage you to do so.
Thank you, Ms. Bentley. Any questions? Thank you. Our next speaker on this same item is Heidi Nasco. Oh, I think you're muted.
Thank you. Hi, I am Heidi Nasco, and I am the partner in charge of pro bono at Dykema Gossett, where for an unbelievable 20 years, I have managed the firm's pro bono activities on a full-time and national basis. Among other things, I have served on the Association of Pro Bono Counsel's Board of Directors, which is a mission-driven organization of almost 400 attorneys and managers who run pro bono practices in over 140 of the world's largest law firms. I have co-chaired the Federal Bar Association's Pro Bono Committee. I have served for more than a decade on various Michigan State Bar committees related to access to justice and pro bono service, and currently serve on the Justice Initiatives Committee. I also serve on the Bar Foundation's ATJ Steering Committee and statewide firm fundraising committee. I am often called upon legal departments of the largest corporations in Michigan and elsewhere to advise them on pro bono and how to define pro bono. I have been called upon to lecture at various law schools on the history of Rule 6.1, its development in Michigan, more times than I can remember. I am a recipient of the Michigan State Bar's highest award for pro bono service, the Kaminsky Award, and several other awards for pro bono services, both in Michigan and nationally. This is not a complete resume of my work in pro bono, but I share this with the court to say that I have had a lot of time to think about pro bono service in the legal profession and the application of rules that govern it. With this, I support the LSAM and Board of Commissioners of the State Bar of Michigan's proposed revision to this court's Rule 6.1 proposal. That proposal largely follows the ABA 1993 revision of Model Rule 6.1. Of significance, beyond just encouraging public service, which is the language of our state's current rule, it encourages lawyers to focus their service on persons of limited means or those entities that serve them. This reflects the stark reality that lawyer-guided access to our courts is still largely limited to those that can't afford it. It is important that the new rule encourages a majority of pro bono hours on service to those who cannot afford legal fees, because it expands access to our courts regardless of income, and in turn expands access to our American democracy. The LSAM's rule proposed also tracks my firm's longstanding rule of pro bono service. Further, a majority of states also follow the pro bono rule, and the state of Michigan will be merely catching up with these rules. Rules in our profession have always provided the guideposts for a well-structured and ethical practice, unifying us under a single standard. This is why defining pro bono in a manner that's consistent with national standards that have had a long record of success in both private and other states is appropriate and a reasonable next step for the state of Michigan. This is why I support LSAM's and Board of Commissioners versions of Rule 6.1. Thank you.
Thank you, Ms. Mansco. Any questions?
Yes, Chief Justice, I just want to real quickly ask Ms. Mansco a question. Thank you, first of all, for being here today and giving us that perspective. I find it really helpful. So since you're working nationally on this issue, is it your experience that most states do count sort of what, the helping a nonprofit with their various needs, even if it's not direct services to people who are lower income? Is that consistent with how others are doing it?
Absolutely. In fact, I would say that the Association of Pro Bono Counsel has literally issued a 20-page guidebook on parameters on how to provide pro bono services and what would count as pro bono for that subsection of that court rule. So this has been dissected probably beyond the scope of this meeting. Just because you're a nonprofit does not mean you are eligible for pro bono services. I mean, we can name a lot of wonderful nonprofits that are also billion-dollar, endowments and so forth. So the rule as proposed does allow for some guidance in that, and our firm, as well as many other firms that have sophisticated pro bono practices, govern, have taken the opportunity to narrow that somewhat, but we absolutely count pro bono services to the nonprofit community, even beyond that, those that exclusively serve the low-income community.
Thank you. Very helpful. I know that's how a lot of folks have operated, and I know in sort of the big law world where you have corporate attorneys, they're probably like, well, what am I supposed to do? So I'm not a litigator. So I appreciate that perspective. Thanks for sharing it.
Thank you. Anyone else? No? Thank you, Ms. Nasco. Next speaker we have on this item is Jennifer Greco.
Thank you. Good afternoon. Can you see me?
We can.
May it please support. I support the State Bar of Michigan's alternative rule to encourage lawyers to provide pro bono services and to contribute financially, and encouraging donations to the Access to Justice statewide campaign. My firm, Altier Law, is a small law firm with 6 lawyers, but we are a leadership firm that donates $500 per lawyer per year to the Access to Justice campaign, and we have for many years. $500 is an average of our firm's various billable hourly rates. Considering the number of hours that we work in a year, this one billable hour per lawyer is not significant to our firm, but can make a difference for legal aid. This has become an amount that is included in our budget, and we expect to cut that check every year. My partners and I believe that it is our ethical obligation to donate to Access to Justice because of the overwhelming need, but also because we're all fortunate to be members of this noble profession. In addition to donating, we have provided pro bono services and donated our time to pro bono organizations. The Access to Justice gap is just too great for lawyers not to do both. As a member of the board of Lakeshore Legal Aid, I have the privilege of hearing from staff members who share with the board their success stories and how they've positively impacted, if not improved, their clients' lives. I've had the experience of helping individuals on pro bono matters to right a wrong or protect them when vulnerable, and it's rewarding and reminds me of why I became a lawyer. When I was State Bar President in 2018, I focused my message, both in articles and in speaking to lawyers across the state, about service and our role as public citizens in accordance with the preamble of the Michigan Rules of Professional Conduct, which provides that lawyers should donate professional time to assisting the poor who cannot afford legal services. That message always resonated with our members across the state and was positively received. During my term as Oakland County Bar Association president in 2010, we rolled out OCBA's Pro Bono Mentor Match program. It was rolled out as a call to service because as lawyers, it's our duty and responsibility. Who else can assist the poor with their legal issues but lawyers? Again, this message resonated, lawyers volunteered. Sometimes it just takes reminding lawyers that this is not just important, but that it's our duty as officers of the court and as public citizens. The rule change is aspirational, but because the need is so great and a need that only lawyers can fill, I believe that a rule that recommends that lawyers do both will result in lawyers doing more because they will understand that more is expected of them. When lawyers embrace both roles, we strengthen our profession's ability to make a broader impact to deliver justice and help more people in Michigan who are facing legal challenges. The need for access to justice requires the time and money, not just of big firm lawyers. All lawyers have the same ethical responsibility to play a part in addressing the access to justice gap, and the State Bar's proposal would encourage all lawyers to do so. So I encourage the court to adopt the State Bar's recommendation that follows ABA Model Rule 6.1, to remind lawyers of their obligation and to encourage lawyers to do more. Thank you.
Thank you, Jen. Any comments or questions? No. Thank you, Ms. Greco. Our next speaker is former Chief Justice Marilyn Kelly. Welcome.
Thank you, Chief Justice Kavanaugh. I'm so pleased that you're reviewing and updating this rule. It's been such a long time since the court looked at 6.1. So long ago has it been that I think I was still on the court at the time. I know that you have no need to hear the shocking statistics that demonstrate how insufficient civil legal aid is in this state for those unable to find and retain a lawyer. You know, the justice gap is the difference between the haves and the have-nots in matters of access to lawyers. Pro bono is, I believe, one of the major mechanisms available to us to close the justice gap. I view this gap as the long continuing deficiency, one of the biggest failures in our legal system. As we're all aware, equal justice under law has long been our goal. The changes to Rule 6.1 that the legal aid community is recommending to you today will bring us closer to meeting that goal. I believe that Jennifer Bentley, Ashley Lowe, Jennifer Greco, and Heidi Nasco know what they're talking about when they say that the changes they're recommending will be a big help to those administering legal aid in Michigan. So I will applaud the court yet again if, in your wisdom, you amend Rule 6.1 as requested by the speakers at today's hearing. Thank you.
Justice Kavanaugh, you're on mute.
It was trying to tell me that too. Our last speaker, thank you, is on this item is Ashley Lowe from the State Bar of Michigan Legal Services Association of Michigan and Michigan State Planning Body. Ms. Lowe.
Thank you very much. Thank you for the opportunity to address this, the court, and talk about this issue that I have been working on for a very long time. I'm the Chief Executive Officer at Lakeshore Legal Aid. We're the largest legal aid provider in the state, and we have a statewide hotline, the Counsel and Advocacy Law Line. And as you mentioned, I'm speaking today on behalf of 3 organizations: the State Bar, of which I am on the Board of Commissioners, the State Planning Body, of which I'm the co-chair, and the Legal Services Association of Michigan. Lakeshore is a member of LSAM. And that group includes the largest legal aid programs in the state and many smaller special focus providers. And together, we provide free legal services to low-income people in over 50,000 cases every single year. We also participate in the statewide fundraising campaign Jennifer mentioned, the Access to Justice campaign that's led by the State Bar Foundation. In case you don't know, the State Planning Body is an association of members of the judiciary, the bar, civil legal aid, and criminal defense programs. All of these organizations agreed, and they are supported by the Justice Initiatives Committee of the State Bar, the Access to Justice Policy Committee, and the ATJ Steering Committee. We all agree on this thing, that the court, it's time to update the rule of professional conduct as it regards to pro bono. And our proposal really differs from the published proposal in 3 main ways that we've heard about here. First of all, the pro bono service and financial contribution, recognizing that full professional obligation that we as lawyers have. Second, our proposal focuses on hours of service, 50, which is the most common number that other states use, rather than a number of cases. Recognizing that giving legal advice to a client at an expungement clinic is one thing, taking on a divorce case that might last a whole year is a completely other animal. And so we want to measure effort rather than just a head count. And finally, the idea that we don't include a dollar amount in the rule was very important to all of us. The time that it takes to modify a court rule, as you can see, is very long. And so in order to keep up with the economic times, with the circumstances that are facing lawyers, it makes sense to have another way of setting that dollar amount. And the Michigan State Bar Foundation is uniquely situated to do that. We believe this proposed rule is flexible and balanced. It allows attorneys to focus their efforts on low-income people while still allowing system improving activities. And so these 3 organizations, the State Bar, LSAM, and State Planning Body, are united in their support, and we urge the court to adopt this proposal in order to increase access to justice. Thank you.
Thank you, Ms. Lowe. Any questions?
I have a quick question, Chief, if you'll permit it. Ms. Lowe, on the last part of your proposal, not including a dollar amount, it occurs to me that one way we might both suggest an amount without tying our hands and locking in a dollar figure for perpetuity would be to link it to the value of a lawyer's labor at a given time. One of the other speakers mentioned that it was based on the average of hourly rates. And it seems to me that we've already made a suggestion on the amount of hours a lawyer should work toward pro bono. What's your response to the suggestion that the dollar figure not be a specific amount, but rather the monetary value of X hours of labor that would apply whether you're a partner at a law firm, straight out of law school, public service attorney? What's your response to that?
Yeah, thanks, Justice Hood. I will tell you that we debated this question a lot, and the idea of not having a specific dollar amount in the rule doesn't mean that there would not be a dollar amount that we would propose. So, under our proposal, the State Bar Foundation would set that dollar amount on a periodic basis. We did talk about the one billable hour. A lot of legal aid programs do a fundraiser around that, and I think that's a way of looking at it. And I think that the foundation would take that into account on a periodic basis when they publish that recommended donation amount to say, this is what we're seeing as the average billable hours, and we recommend that folks contribute this amount.
Okay, thank you.
Thank you.
Thank you. All right, our final item for this hearing is ADM file 2023-35, and that regards the proposed amendment of the Michigan Code of Judicial Canons 3 and Michigan Rules of Professional Conduct 6.5 that would incorporate the ABA Model Code of Judicial Conduct Canon 2 Rule 2.3 into Michigan's code and rule to prohibit bias, prejudice, and harassment. And we have a number of speakers on this item. The first speaker is David Peters from the Pacific Justice Institute.
Madam Chief Justice and the Justice of the Michigan Supreme Court, thank you for the opportunity to speak. My name is Dr. David Peters. I am an attorney with the Pacific Justice Institute. We are a nonprofit legal ministry dedicated to protecting religious freedom and civil rights for people of all faith. The First Amendment is the issue in this debate, and the ultimate question is whether people with sincere religious beliefs can be forced to adopt and articulate beliefs that are contrary to their religion. This is not just about free speech, but this is also a deeply moral and religious question. I do not pretend to represent all or even most Christians, just as nobody on the opposite side of this debate can step forward and claim that they represent the views of all or even most people suffering from gender dysphoria. I present to your honors the beliefs of a subset of Christians and Christian lawyers who sincerely and honestly believe the words that are written in the Bible. And I submit that the views of this group of Christians hold at least equal value, if not more value, under our constitutional framework than the views of non-religious groups. Nobody is claiming that a transgender individual cannot call himself or herself whatever he chooses. Nobody is trying to force transgender persons to state beliefs which are contrary to their own personal and moral code. Rather, the attempt in this case appears to be to force Christians to state beliefs with their own mouths that are contrary to what has been believed to be Holy Scripture for thousands of years. Some Christians believe in Holy Scripture, and those words are not negotiable. They are not false. They are true. And many Christians, in fact, believe those words are the light of the world and were written to us as a gift from God Almighty Himself. The book of Genesis states unambiguously that God created man in His own image. In the image of God, He created them. Male and female, He created them. The Gospel of the New Testament has Jesus Himself affirming this fact. He who created them from the beginning made them male and female. God Himself states this several times, that the gender exists and seeking to change your gender is contrary to God's will. The book of Deuteronomy states a woman must not wear men's clothing and a man must not wear women's clothing, for whoever does these things is detestable to the Lord your God. Now you may take issue with that assertion. Many do. You may believe that God gets it wrong, that we are more enlightened and more knowledgeable than the creator of the universe, and under the First Amendment, all of us have that right. What we do not have the right to do is to force someone to accept your beliefs with their mouth. As a Christian, I would never dream of forcing transgenders, for example, to recite the Apostles' Creed, affirming the might and glory of our God. Yet the same consideration is not given to Christians. It is time to put a stop to this censorship regime that is evolving in this country over the last few years, and it is time to acknowledge that compelled speech that violates your conscience and your religion cannot and should not be permitted in this republic. Thank you.
Did it again. Thank you, Mr. Peters. Any questions or comments? Okay, our next speaker is Laura, is it Namo from the Christian Legal Society.
It's NAMO. Thank you so much.
Thank you. Go ahead.
Christian Legal Society respectfully opposes the proposal to amend Rule 6.5 of the Michigan Rules of Professional Conduct. Leading First Amendment scholars have identified ABA Model Rule 8.4G as a speech code for lawyers. On its face, the proposed rule is such a speech code for lawyers. The extreme breadth of the proposed rule makes it even worse than the ABA model rule because the proposed rule outright bans words that communicate any bias for or against any person involved in the legal process. For example, under the proposed rule, a Michigan lawyer could be disciplined for arguing to the court that the police used racial profiling when stopping his client. The same is true of lawyers who speak on issues of gender equity or domestic violence or income inequality or any controversial topic. These concerns are compounded by the fact that the proposed rule lacks any mens rea requirement. The proposed rule clearly violates the First Amendment. The U.S. Supreme Court has made clear there is no professional speech exception to the First Amendment. In NIFLA v. Becerra, the court held the government restrictions on professional speech, which includes attorneys' professional speech, are presumptively unconstitutional and subject to strict scrutiny because they are content-based speech restrictions. Any government regulation targeting speech must survive strict scrutiny. The proposed rule cannot do so. In NIFLA, the court reaffirmed what it stated in another case striking down a state's regulation of lawyers' speech. In NAACP v. Button, the court instructed, if there is internal tension between proscription and protection in the statute, we cannot assume that, in its subsequent enforcement, ambiguities will be resolved in favor of adequate protection of First Amendment rights. Broad prophylactic rules in the area of free expression are suspect. Precision of regulation must be the touchstone in an area so closely touching our most precious freedoms. The proposed rule's comment further lays bare the conflict with NIFLA and Button when it acknowledges, obviously, it is not possible to formulate a rule that will clearly divide what is properly challenging from what is impermissibly biased, prejudicial, or harassing. A lawyer's professional conduct must be employed here with care and discretion. No, it is the state of Michigan that has the constitutional duty to act with care and discretion in any regulation of Michigan lawyers' speech that it promulgates. In this time of heightened political polarization, the proposed rule is bad policy. That political affiliation is one of the proposed rule's protected classes only exacerbates the likelihood it will be used to punish lawyers for their political beliefs, speech, and activities. A rule that can be used to discipline lawyers for their speech on controversial issues should be rejected as it constitutes a serious threat to a civil society in which freedom of speech and religious and political beliefs flourish. Our democracy depends on lawyers' ability to speak freely. Michigan lawyers can ill afford to wager their licenses on a rule that may be used to target their speech. Public discourse and civil society will suffer from the ideological straitjacket that proposed Rule 6.5 will impose on Michigan lawyers. Thank you.
Thank you, Ms. Nemo. Any questions or comments? No? Okay, thank you. Our next speaker is William Bloomfield from the Catholic Diocese of Lansing.
May it please the court. I'm General Counsel of the Catholic Diocese of Lansing, and I'm commenting today on behalf of my client, Bishop Earl Boyer. As our written comment explained, the Diocese of Lansing opposes revision to the existing Canon 3 for judges and Rule 6.5 for lawyers. In brief, 1. The existing rules are sufficient, requiring judges and lawyers to treat every person with courtesy and respect. This language is clear, sensible, and accords entirely with the Catholic teaching that every person is created in the image and likeness of God and so possesses inherent dignity. The new language is vague, unnecessary, and driven by sexual ideologies that contradict both reason and traditional religious belief. 2. Catholic teaching, rooted in both faith and reason, defends the inherent dignity of all persons, yet also condemns those sexual ideologies that deny the significance of biological sex or deny the nature of marriage as being the lifelong union of a man and a woman ordered toward the generation of a new life, or that promote sexual activity outside the marital union or promote so-called gender fluidity. These ideologies are harmful to the common good and to individual persons, and the church and its members will continue to proclaim these truths in genuine love toward those harmed by these false ideas. Yet the proposed amendments could be used to accuse Catholic judges and lawyers of manifesting bias or prejudice, or harassment for simply living out their religious convictions, such as not using preferred personal pronouns, not affirming same-sex marriages or acts, opposing adoption by same-sex couples, or otherwise opposing gender ideology. Under the current rules requiring courtesy and respect, judges and lawyers can interact professionally with all persons while maintaining their religious integrity. 3. The proposed rules impermissibly regulate speech and infringe the free exercise of religion, creating an unnecessary conflict with the U.S. and Michigan constitutions. Recent Supreme Court and Sixth Circuit decisions, such as 303 Creative, Fulton v. City of Philadelphia, and Merriweather v. Hartop, have affirmed First Amendment protections in this area. The court can easily avoid any constitutional conflict by maintaining the current rules requiring courtesy and respect. 4. Lastly, the court should remain neutral on contested issues. The proposed rules create the appearance that the court is taking sides on a contested cultural and political issue and risk undermining the court's legitimacy and credibility. The court should avoid such an appearance, especially here, where the existing and neutral rule requiring courtesy and respect already ensures the respectful treatment of all persons. The Diocese of Lansing respectfully requests that the court maintain the existing rules which already protect the dignity of all persons while avoiding unnecessary constitutional and religious conflicts. Thank you.
Thank you, Mr. Bloomfield. Any questions?
I just have one question. Counsel, I appreciate the issue kind of in the generality, but what is the main, if you were to highlight your main concern, what would the main concern of these initiatives be?
Yes, it's that language manifesting bias or prejudice or harassment. It substitutes something that was easily followed, the courtesy and respect requirement for all, with something that is vague and could be used in a political way to attack beliefs or opinions that are not in favor.
Can you give me an example?
Well, the examples that I have are the concerns that we have are preferred personal pronouns. Is that something that this language could be used to regulate? It feels like it is. Same thing, views regarding same-sex marriage or statements to that effect. Could those things, even outside of a courtroom, be used to punish attorneys? And that's the concern that we have with this rule.
Have you seen this happen in other states?
I'm not familiar with the application in other states, Your Honor.
Okay, thank you. I just wanted to get a sense of, I understand your concerns and you laid them out beautifully. I'm just trying to grasp kind of, is this a theoretical concern, which I can understand is concerning, or do you consider this to be a real concern that could be actually acted upon?
Understood. Thank you.
Thank you. Our next speaker is Kimberly Uhuru from the Attorney Grievance Commission.
Good afternoon, Chief Justice Kavanaugh, Justices of the Court. The Commission supports the goal of encouraging non-discriminatory treatment of all persons in the legal process and believes that the proposed language supports this goal, and accordingly, the Commission supports the proposed language. I think it is helpful to consider the historical context for the current 6.5 that we have in place. The court in 1989 created an independent and nonpartisan Citizens Commission to study the issue of bias in the Michigan courts and in the Michigan justice system. And that Citizens Commission made findings that there was not only a perception of bias along the lines of race and gender in the Michigan justice system, but also that those perceptions were rooted in fact. And following up that commission's study, the court created in 1993 a task force for racial and ethnic issues to further study the issue of bias and make recommendations. And that task force did make recommendations to the court, including the adoption of what has now come to be our current 6.5. And I think that context is important because the court was seeking there to address the issue of bias and prejudice in our courts and in our justice system. An issue that is still with us and it still needs to be addressed. So the commission supports this proposed amendment because we believe it strengthens the current rule. However, the commission would ask that the court preserve the current language requiring lawyers to treat others with courtesy and respect. That language has been instrumental in addressing complaints where lawyers engage in incivility that is not at all related to bias or discrimination. Most of those cases involve lawyers using vulgarities or profanities in a legal process, and they generally result in private warning letters. However, in the most egregious cases, we have charged 6.5 and prosecuted those cases and obtained discipline. And some of those cases are cited in our written comment. We believe that the current language of the rule greatly helps maintain the civility and integrity of the profession and would encourage the court to retain that language. The commission thanks the court for this opportunity to address the proposed revision.
Thank you, Ms.
Counsel, I have a question. We've heard a lot of concern put forth by members of the religious community and different scholars in that regard. How do you respond to the concerns that have been put forth about religious freedom as it pertains to this? Do you think this could encumber it? Do you think that this could have an impact on it? What would you say is the overall effect as it pertains to what we've heard so far from the people that have spoken prior?
Obviously, the right to speech and the right to exercise religion is a right that is granted by our First Amendment. It is an important right. However, we do believe that this rule serves a compelling government interest in also protecting the rights of people who are engaging in the legal process to be free of discrimination, free of bias, and free of harassment based on protected classes. That is also an important right. I also think there are narrowing features to this language. The rule is limited to conduct that happens in the legal process, and that's the language that we currently have. And when we receive these complaints, we get complaints about lawyers' personal conduct that may involve homophobic slurs or racist slurs. We don't prosecute those because it's not happening in the legal process. We are capable of looking at the complaint and determining whether or not the conduct is happening in the legal process and the lawyer is acting as an officer of the court. That's a requirement of the rules. So that narrows greatly what we can pursue and what we would pursue as an office. So I do think that this rule is capable of meeting constitutional scrutiny. I will say that the current rule that we have, I think is sufficient to achieve these goals, even if the court does not revise the rule. We've had very rare occasion to prosecute those types of cases. Most of them are resolved privately, but occasionally we do have very egregious examples. And one of them is cited in my comment where we did obtain discipline for that type of conduct. So I think if not revised, we can still reach the court's goals or the proposed rules goals. But I think that the language strengthens the rules and would meet constitutional scrutiny.
Thank you, counsel.
Thank you.
Thank you, Mr. Huru. Our next speaker on this item is Michael Lieb.
Thank you, Chief Justice, and may it please the court. I'm active in the state bar and have been deeply involved in professionalism and civility. And I speak for myself and no entity. I specifically do not have a position on the proposed change in the judicial canons. I oppose removing the courtesy and respect language. I think it's an important piece of professionalism and civility messaging. I would point out that the court's administrative order from 2020 specifically talks about not acting upon or exhibiting invidious bias toward people involved in the justice system and treating people involved in the justice system, quote, fairly and respectfully. If the court is inclined to add the proposed anti-discrimination language, I would respectfully request it be placed in MRPC 8.4, which is where the model rules place that language. I think the language we have right now in 6.5 is extremely helpful for some of the reasons that you heard from the AGC. As a practical matter, I'm not aware of a need to change the rule. Are there statistics, for example, that support an argument that discrimination problems by lawyers are not being pursued? What is the problem we're trying to fix? That's something I look at when I'm looking at new legislation and suggestions of new legislation. So I would refer the court also to the comments made by Gerard Mantis. He provided rather lengthy and detailed comments that are thoughtful. My final comment is this: if the court is inclined to add language to the commentary, I would ask that it consider involving the State Bar Special Committee on Professionalism and Civility to assist in that language. So I appreciate your time and thank you very much.
Thank you, Mr. Lieb. Any questions? Thank you. Our next speaker is William Wagner from the State Bar of Michigan Religious Liberty Law Section.
Chief Justice, and may it please the court. I am William Wagner, and I'm speaking today on behalf of the State Bar of Michigan Religious Liberty Law Section, of which I previously served as chair. The section previously filed a written comment, as I have also filed another comment along with former chair of this same committee. So thank you for the opportunity to address ADM 2023-35. On behalf of the State Bar of Michigan's Religious Liberty Law Section, our message is simple. Keep the rules we have. Canon 3 and Rule 6.5, they already require judges and lawyers to treat everyone with courtesy and respect. They work. The proposed amendments don't fix the problem. They create constitutional ones with due respect to, the previous speaker that suggested that there was a compelling interest here. Let's start with the first principles. The First Amendment protects both free speech and the free exercise of religious conscience applied to states, obviously through the 14th Amendment. These protections are not limited to popular ideas or state or court-approved motives. They safeguard the right to think, to speak, and to not be compelled to speak. And our legal system depends on a robust marketplace of ideas, especially in courts where the law is tested and refined. And these amendments prohibit the use of words that manifest bias or prejudice, harassment, keyed to a list of protected characteristics. That's content-based regulation. It turns on what is said, and in practice, on the viewpoint that is expressed. And so under this court's and the U.S. Supreme Court's jurisprudence, these rules are presumptively unconstitutional and trigger strict scrutiny. And you can rebrand speech as conduct, to, come do a little subterfuge to try and get around the First Amendment, but rebranding speech as conduct does not solve the problem. When the conduct is expression, heightened scrutiny applies, all the same. And attorneys and judges do not surrender their First Amendment rights when we enter the profession. And so worse, in my view, the amendments invite viewpoint discrimination. Speech aligned with the state's preferred views remains safe. grounded in religious conscience about contested questions of sex and gender, that gets chilled or punished. And the free exercise clause additionally presents a second independent constitutional defect. They're substantially burdening the free exercise of religious conscience by threatening discipline for religious expression rooted in sincere religious conscience and belief. Supreme Court has repeatedly said you cannot do that. And I'm out of time, but the final concern is due process. Words like bias and prejudice and harassment, what do they mean? They're not defined. The comment concedes that a clear line can't be drawn. This is going to get overturned on the U.S. Supreme Court if we go forward. The current rule solves the problem. It works. And it sounds like, others have conceded that it works. So let's keep the current problem and protect both civility and the Constitution.
Thank you, Mr. Wagner. Is it your position or your understanding that you think the existing language of maintaining courtesy and respect would in fact prohibit words and conduct that manifest bias, prejudice, and harassment?
I can't answer that because I don't know what the second thing means. It's all in the eye of the beholder or the definer. I do say, though, that any concern that is raised under the proposed rule can be resolved if you've got something that is, that wrong. I'm not talking about regulating speech, but if somebody is treating somebody with that kind of that much disrespect, then it certainly can be handled, under the current rule. If you're going to then decide that we should regulate speech or should regulate especially religious speech or religious conscience, now you run headlong into the First Amendment. And here the court normally the court decides cases and controversies that come before it, but here the court is acting as a rulemaker, as a government actor, and so the court, like every other government, is limited by the First Amendment.
So just to clarify, your position that the existing rule requiring attorneys to act courteously and respectfully does not implicate the perhaps religious freedoms that you say are implicated by prohibiting bias, prejudice, and harassment?
I don't think so. And if they ever were done so in a way that did, you would have an applied as challenge that that could be used to protect that liberty.
Which I don't believe we have any cases that have so far challenged that under the existing rule. Okay, thank you. Any other questions? No.
Thank you.
All right, thank you, Mr. Wagner. Next speaker is Marcia McBrien from the Catholic Lawyer Society of Metropolitan Detroit.
Good afternoon, Chief Justice and Justices. Marcia McBrien on behalf of the Catholic Lawyers Society of Metropolitan Detroit, and I'll also be making some remarks which are my own. So it's clear from the many comments in opposition that the vast majority of commentators representing hundreds of attorneys and judges think that the proposed changes are a problem. It used to be a given in First Amendment discussions that the response to ugly speech was more speech. These proposed rules, instead of reaching for the duct tape in the name of eliminating bias, prejudice, and harassment. Is civility a high value for the legal profession? Yes, but it isn't the only one or even the highest value. And I quote, "A bar composed of lawyers of good character is a worthy objective, but it is unnecessary to sacrifice vital freedoms. In order to obtain that goal, it is also important both to society and the bar itself that lawyers be unintimidated, free to think, speak, and act as members of an independent bar." That was Konigsberg v. State Bar of California, 353 U.S. 252, 1957, and cited with approval by Justice Michael Kavanaugh in dissent, Grievance Administrator v. Feiger, 476, Mich. 231, 2006. I'm just going to skip the rest of my prepared statement, and I'm going to go to Justice Bernstein's question earlier. And Justice Bernstein, you were asking about what is the potential impact of these rules, and have, do we know what the impact has been in other states that have adopted similar rules? The concern I have, and I'm just speaking for myself right now, not for the Catholic lawyers, and you know this yourself as an attorney who's been in private practice, what our clients expect of us is a vigorous defense, zealous advocacy to make every argument that can be maintained under the law. What I see with these proposed rules is a chilling effect, which will achieve the opposite end. You'll have lawyers walking on eggshells, perhaps not making the argument or raising the issue that should be raised. And it's hard to measure that. How do we find the argument that wasn't raised, the issue that wasn't brought forth, the statement that wasn't made? I think that's a very real danger if the court goes down this route. So that would be my response to your question. I would also point out, that the underlying assumption of these proposed rules seem to be that some words cause harm and that therefore those words must be silenced, or if they can't be silenced, punished. Do we really want to live in a country where that is the rule? I would warn the court about where that assumption can lead, taken to its most extreme and violent end, as we saw in Utah 2 weeks ago. Thank you.
Thank you. Any questions or comments? No. Thank you, Ms. McBrien. All right, our final speaker on this item and for the afternoon is Bob McGill. Mr. McGill.
Oh, thank you. Thank you for this opportunity. Can you hear me?
Yes, we can.
For this opportunity to address you. Let me start by saying that I love being a lawyer. It's been almost 57 years in practice. Yeah, I know I don't look it, but I appreciate your thinking that. Nevertheless, I admit I was admitted in 1968.
Mr. McGill, can you activate your camera, please?
Yeah, let's see. Oh, I'm sorry. I apologize for that. Uh-oh, now you get to see me. Apologize for that too. During these 57 years, I've worked for the rich, for the poor, for big firms, corporations, poverty programs. I've engaged in teaching law. I've litigated, mediated, arbitrated, written, and counseled clients. And I have at one time been counsel for all 50 states, for all their attorney generals. It has been a wonderful career. I loved it. I'm gradually retiring. In addition to my writings for legal journals, I also wrote things for the local and national press, and I spoke publicly on the radio and in live audiences on things that were often very sensitive matters, sex, religion, and politics. But I was always free to say and write what I believed, and never once did I have a concern that someone, somewhere, would grieve me for some speech offense. So freedom is my theme, not for myself, since I'm gradually retiring, but for all younger lawyers and future lawyers. I want them to have the same freedom I have had. So I speak today against the proposed changes, since they will reduce the freedom of lawyers and impose an undue burden on judges. I will not discuss the legality of the proposals. That's been well done by others, particularly by that 40-page memo by the group of Michigan lawyers. Instead, I just want to say something about the practicality of the proposals. I recall when the bar first started focusing on civility, I was presenting a motion in federal district court, and the judge interrupted me, not once, but 3 times, claiming that I was being uncivil. I thought I was being very civil. Clearly, there was a problem between us in interpreting what civility meant. The same difficulty is going to be here, too, as well as interpreting and applying the rules, words of discrimination, harassment, etc. Even if a judge is not hyper-focused like that federal judge on the rule change, it'll be one more distraction for a judge whose work is challenging enough without having to be a speech cop. I note that a lawyer in a court proceeding, if he were to offend somebody and the judge did not take action, both of them could be grieved. Nobody needs that. Most importantly, I perceive the proposed changes would extend an invitation to several groups of people that I know who would cause mischief and overburden the grievance process. Those described in Chapter 6 of Dr. Bergler's book on the basic neurosis. These are neurotic injustice collectors. Next are those who, while not neurotic, are hypersensitive. Next to the warriors for political correctness. And finally, our most dangerous are those described in David Horowitz' books, Dark Agenda, those whose agenda is to push religion, especially Christianity, out of culture. Don't invite these people to make life difficult. Keep lawyers free. And Justice Bernstein, I want to add that you asked some questions about actual application. If you look to the briefs of the Christian Legal Society and the briefs of the group of 40 lawyers, you will see actual cases where discipline was imposed for violation of a rule similar to this. In Indiana, and I think the other state may have been Missouri or Minnesota. Anyway, they're there. So thank you very much for listening to me. I appreciate this opportunity.
Thank you, Mr. McGill. Any questions? Nope. All right, thank you. That will conclude our hearing for this month. And we appreciate everybody being here and offering your comments. The court is adjourned. Thank you.